like 2 days ago, and this is something he's really concerned about.
That's great.
I would
Great.
suggest you all talk to him.
I was that, yeah, that kind of goes along with
I really would,
everything.
because he brought the subject up and he said it's his #1 priority.
Maybe we could be at the meeting then.
That would be
Yeah.
awesome.
He's also a former prosecutor.
Yeah.
Yes, he does.
And then my other questions actually are for this gentleman over here is,
We kind of moved into public comment, so keep going.
okay,
Yeah,
I
go ahead.
don't wanna, is, what is the water district, your area doing, are we, and I don't know your rules or anything like that, to test our drinking water and our sewage, because from my understanding is when they dump these chemicals down the drain, it means you have to put more chemicals in our sewage. And, you know, obviously, I know that small amounts of THC are water soluble, but there's other issues if some of that's a byproduct.
It's not one of the constituents that we have to test for yet.
But
The
should
state,
we?
the state actually puts the test limits on us and what we have to test for and how often we have to test for it.
But shouldn't we be? Because I can tell you Del Rio is loaded with grow houses. I can tell you that for a fact. And the sheriff's office already knows about it. Because I've already turned it in, so. Yeah.
I got a question for you.
Yeah.
I remember the rules being, it used to be like 12 plants per person in the household.
I have it right here.
Yeah, what is that now?
It is, it's 12 plants, in here, if I might, I'll give you this. But it's this area right here, and then if you read it, it's really only 12, and if you're gonna do medical marijuana, which is amendment 20, and correct me if I'm wrong, then you have to get a license, and they said, Tuesday that there was no license out here in the unincorporated El Paso County. So anybody over 12 is in violation. And it's 612, it's.
They also mentioned that you can be, there's this gray area because state says you can have up to 99.
Right.
And the county says 12. And so people are pushing them rules on it.
And the county, and the state's saying they want county to enforce it, and that's what Sheriff Elder's saying.
Yeah.
So,
Right.
yeah. So I think it is an issue, and I would like to see some kind of forum, and I'm
We will,
willing
we'll
to
get
help you with
together.
that, so.
Okay, all right, well. we'll
Because
get
I've got some
together.
contacts too.
Yeah, I know, yeah, some of the people you met would be good. for
Yeah.
that meeting. All right, we'll take this up again in another meeting.
Right, thank you.
Robert?
Okay, I do have two questions. So if we don't sign that agreement, are we allowed to use the parks and trails? Because that would be something that does affect our children on what we do, and we don't want to be going against the board's regulations.
Is that,
You know, I will read the form very carefully, and I will give the district an opinion on whether it precludes use of the trails and the parks. And I will have that question answered tomorrow.
And also, are you aware of the agreements that were signed originally that have the date, and have you looked at those as far as the contract law side of it goes?
Well, it's not a contract, because in the contract, there's quid pro quo, this for that. The district is not promising anything in exchange. The district is merely having you give your consent, your signing the agreement that you're releasing the district from liability.
Not
for
on the
providing
original one, it
services.
wasn't. The original one was saying that the district are going to provide this service, and we have to follow the rec center regulations. And we have that with
right.
a specific ending date, and so that's the thing, you know, part of what is scaring a lot of people, and it's making them believe that the water district is using undue influence to get them to sign away their rights, with the fact of having it in the new one saying that they're not allowed to sue for any kind of damages in any situation.
My view on that is that the district has the ability to enact broad policy, and that's well within the district's authority. And to say undue influence is kind of a tortured analysis, and it doesn't apply.
It's not
at
tortured
all.
when you're being told if you don't sign the new agreement and you don't pay for the services, your water's going to get turned off. And if you don't sign the agreement, you can't use facilities that you're paying for.
And that's a legitimate enforcement tool for government to use to make sure that the fees are paid
Yeah.
and the revenues are kept.
But we are paying the fees based on the agreement that we have in place with them, which we have a specific end date placed with that contract that was signed.
I don't know if there's a specific end date, but again,
With
the
us,
district
there
has
is-
the authority to enact broad policy changes, which it has done.
So you're saying that the district is available to change the contract that we've got them midway through the contract?
I don't think it's a contract at all, but that's a point of disagreement. But even if it was a contract, yes, the district has the authority to enact broad policy. There's a rational reason for enacting that policy, and I don't think any court will strike it down.
And can I ask them what the rational reason is for trying to waive everybody having their rights to be able to sue for gross negligence?
Your question has an assumption in it as to facts that I'm not sure are correct.
In the agreement, it does say that we are not allowed to sue for gross negligence, whether the district was aware of it or not aware of it.
I would have to look at that.
And, I mean, I would
I
have
think-
thought they would have passed that by you
I
before
think-
sending it out
Well,
to
that
the
was
district.
enacted long before I was district officer.
No, I don't have a copy of it. I forgot to ask Lisa.
I
There's
can grab a copy
the
of
current
it.
one and the previous one, so
Do
we
you
can
have a copy
compare
of
the
it,
two.
Robert?
I can get a copy of it.
Where it says gross negligence?
Can I ask what the heck they're talking about? Because I know I live in this community, I've not been asked to sign crap, so.
Yeah, they're talking about the waiver, the usage agreement, the waiver to use the rec center. Waiver of liability. Connie?
I just have a comment. Whether I agree or disagree, I appreciate for why you're talking to us about things that have been off the table for a long time. And we're able to talk to him, we're able to have a good conversation, and I appreciate that because that has not always happened. Why usually just sits there and just gives us looks and the board says, that's the end of it. So I appreciate being more open and him giving us information without having to bully, if you wanna call it bullying, you know. And so that's just my comment on that.
Okay, thank you. Mr. Fisher?
Madam Chair, did I mishear you or somebody up on the board say there's a different way to do the covenants of some kind of organization or something?
Oh, okay. You could form an HOA yourselves, a homeowners association, and give yourselves the authority to enforce covenants. But
Through-
that's another whole,
Would that be through the board?
no,
No.
no, that's
You
totally
would
separate.
still have to reestablish the covenants again.
So you would have to go-
I mean, it's a circle.
You'd have to-
It's-
yeah.
it's
You'd have to go through
frustrating.
the same process of what the gentleman said about going to and writing the whole thing out and
Yeah.
You'd have to
doing
make
everything. And
covenants.
Yeah.
then individuals would have to take it to court to,
No,
no,
yeah,
no.
Bill, yeah, go ahead and.
No, to amend covenants, you don't have to go to court. That would be amending a private contract. And you would not have to go to court for that.
well, how many people would have to, as an example, if you had 50 homes, how many of the 50 homes would have to?
70%
70%, that's agree on.
of the homeowner.
So it would be a true statement that you could, to get code enforcement, you would have to either amend the service plan or form an HOA, and either one of those would involve additional fees that you have to pay monthly because that's a home use service.
Exactly.
Okay, that's- I understand that.
I think you misspoke. I think that's, yeah, in order for the district to amend its service plan, the covenants in each filing would have to be amended to allow the district to engage in covenant enforcement. Is that correct?
Well, a filing
A filing.
could amend their covenants, and the district could amend the service plan, and then the district could enforce for that filing, and then it would be that filing, their fees would have to be set to pay for those code enforcement. So it does not have to be enacted district-wide.
That would have.
The service
But-
plan would
Filing
be,
can
though.
get their
But
own.
each filing, first of all, has to amend their covenants by 70% vote of all the residents in that filing. And then the district can then amend its service plan to affect that filing only and engage in
But
covenant
we'd have to be
enforcement.
approved by the county, right?
But
Well-
it also then, it goes a third step, the county has to approve.
Well, we're close, but let me clarify a couple things. The district could go and ask the county to amend the service plan to give the district covenant enforcement powers. And you would not have to do it ad hoc for each filing. You could just ask the commissioners to give that power to the district. But then the district, think of it as a light switch, could not flip on that power until a filing amended its covenants to allow the district to do it. So the processes can happen simultaneously. Now, the covenant change would not have to go to court, but the service plan amendment would have to go to court after the Board of County Commissioners approved the change. But taking it to court's not a lawsuit, it's just you file a form, the court signs the order, proof it's done.
So, assuming that they were able to get together and amend their covenants, and they wanted us to enforce them, and we change our service plan, that doesn't automatically mean that we are going to enforce covenants throughout the district, but just for their filing.
Correct, yeah, right. You can give the district the power, but you can't go and implement that power until the other half is, of the circuit.
Well, I'm just
is
thinking
complete.
there are other filings that don't want their covenants enforced, and I don't want them to think that we would do that against their will.
Right, there's no way the district could do that against their will.
Okay.
But the filings can individually get someone other than the district to enforce their covenants,
Right.
can't they?
Yes, they could pool their resources and hire an attorney to do it right now and recover their attorney's fees, or they could form an HOA to do it.
So they don't have
There
to
you
form
go.
an HOA?
They don't have to. The simpler and quickest way right now would be for a group of residents to get together, pool your resources, and hire an attorney and slap a lawsuit on them.
What's your fee?
No. No, but I can recommend some attorneys to you. He knows some people. I do. And it really would not be as long and a complicated a process as you think.
Maggie was first. Maggie was first.
This is, I'm
You went
gonna,
out to see us already.
I just want to
All right, go ahead.
switch topics just a tad. I know on your website you say you're all into transparency, and I think we've made strides. But specifically, clarify for me, please. I understand why there's an executive session, and I understand that there are topics that you discuss, be it personnel or whatever, that are not part of the public domain. I get that. What I don't understand is then why do we have attorneys' reports down here with resolutions which mean absolutely nothing to me? You vote on them and you ask for discussion. So I'm assuming if you ask for discussion, in theory, you could talk about whatever this resolution is, although you haven't. It seems like there's a big disconnect
It's
here.
just
It's
Robert's
like,
Rules of Order that's how meetings are conducted, when you have a motion, a second, any discussion, then you vote. That's all it
Discussion
is.
is for the board, though.
Yeah, this discussion is for the board, in case you have some questions.
Could the resolutions be titled, or could you tell what you're resolving? Could brief, in that, I think that's really what she's saying.
Exactly.
well,
Yeah, because when you say it, for me, it's kind of like, well, what does that resolution mean?
yeah, I wasn't asking that. I guess what I was asking is if this just has to do with the board and your discussions, why are we taking up time here? You've got an executive session. Why isn't it tied up there?
Because we can't
since
vote.
it's-
We can't vote in executive
session.
session.
There aren't.
And so it's just kind of finishing up what we just talked about in executive session, voting, and then we move on.
Okay.
I've seen where the residents have been invited to the executive sessions with no comment. They can't make a comment because the board's doing their thing.
Section is closed.
Is that your vote?
I take it differently.
So these resolutions will not be made public?
Yes,
Yes,
they
they
will.
will be made public.
Now they've voted on it.
They're all published.
But they aren't titled with what they relate to, they just find out?
They will when they're published, yes.
But I
But
think
they're not
what
official until after I've signed them.
But I think what she's saying, or the other people are saying, is we don't need the particulars on it, but if you give us resolution -07, -28, dash whatever, you have a little something at the end of it, so we kind of know what it is. We're not asking
Okay.
for the whole thing, and we
Yeah.
know, you know, and then you can say, and like I said, and I hate the word transparency, but if you want to do this kind of stuff and you want to have it open to the public and you want people to feel confident with you guys, then you need to say, we'll list that, but if you want the full resolution, it will be in the minutes when they're put on the website. Now, unfortunately, sometimes the minutes aren't put on the website in a timely manner. So,
Well, we do have to, what?
Sometimes the minutes aren't put on the website because it was heard on the missed meeting or.
Oh, yeah, yeah. And it does take a month. I mean, it's not like,
that's okay with the month, but 3 months is not good.
Yeah.
Yeah.
Yeah, but if we miss a meeting, you can't approve the minutes until the next meeting.
Well, okay, you know, I'm not on the board, I don't know all the things. I'm just telling you as a resident that has lived here a long time, has come to many, many meetings where I've seen nobody else that's in this room on a regular basis, that this is what I'm looking at, and I think we have a right, if we pay our fees, we're here, you want us to be a part of the community, then you need to treat us like a part of the community, and you work for us, we work for you, however, you gotta work together. That's the bottom line.
well, I guess typically, and you know this, you just mentioned it, there's hardly anybody else here. So
Exactly.
you gotta breeze through some of these and just use numbers. It's like, well, we know what we're talking about.
Right, but is that fair to, you know, is that fair to somebody like me or like Maggie or some of these other people that come on a regular basis? Is it fair to us, for you guys to just say, we know what it is, but, there's only 3 or 4 people here and you don't matter?
Well, sometimes there's nobody here.
You know.
I understand.
We've been running, you know, like this, you've been coming to it for a while. I came to it for a while before it became a board member.
Right.
And it's been numbers.
Right.
And I think that's just the way we've always operated. But I hear your statement. If we could add just a little bit, you know, I think that's something that we as a board need to discuss and say, hey,
Sure.
you know, what can we put in there? We haven't, I mean, at this point, you know, it's been voted on, it hasn't been ratified. So there's a procedure that happens even after that, and that we work with the attorney, and then it's public noticed.
Right.
So there's a couple things,
Sure.
but I agree with you. So I think it's something we'll definitely need to bring up and talk about, so that you guys have a little bit, you know, what the hell are they talking about? It's, you know, it's like code
Exactly.
language, you know,
Yeah.
so.
And I think that's all
That's
she's
great.
asking.
Yeah,
Okay.
no, I think
Yeah.
it's great.
Okay.
Thanks.
Any other comments?
Madam Chair, in answer to the question,
Sure.
I did not have a copy
Robert's
of the
back.
document, but I do now. It's asking for a release of the district for simple negligence, not gross negligence, or certainly not an intentional tort.
So,
You have a document that says gross negligence?
Yeah, I forgot about the gross, I thought it said gross negligence. But it does say that, that you agree to defend, indemnify and hold harmless the district for any damage, attorney's fees or cost out of such claim or lawsuit blamed on my petition and any activities, regardless of cause, including negligence of the district.
Well, I don't think intentional, alleged negligence. and I don't-
Regardless of cause is regardless of cause.
It is, but I can tell you that in any situation where if somebody was harmed by gross negligence or intentional conduct, I don't think court would interpret regardless of cause to include gross negligence